Call your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
And how do you choose to go forward?
Pro se, please.
Okay.
Your Honor.
You even know the right term. Okay.
And there's no victim in this alleged crime. I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torture.
All right, everyone. Today we're looking at one of the more unusual courtroom moments involving someone who identifies as a sovereign citizen. He uses the same worn-out arguments we've seen before, like he's discovered some hidden legal shortcut. The judge's reaction? He actually chuckles, and honestly, it's hard to blame him. It's incredible how confidently some people reject well-established laws in favor of personal beliefs that have no legal grounding. At some point, you have to wonder how so many people come to believe that the law doesn't apply to them. What do you think led to this mindset becoming so common? Of all the things someone might say when being arrested, this man chose, "I'm too drunk to be held responsible." Not "I didn't do it" or "you've got the wrong person," just a straight up.
And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's
I'm not a person. I am one of the people. Thank you.
Okay. Thank you. All right. So for the record, that's my finding. Hey, hold on. We're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too.
Acknowledgement of the situation, with alcohol as the excuse. It's moments like this that show a deep misunderstanding of how the legal system works. Individuals truly believe that talking in circles or using certain phrases can exempt them from accountability. But saying you were intoxicated during an incident doesn't make it legal. Many of these cases also share a common pattern: the belief that they're being unfairly targeted. Do you think this mindset comes from misinformation, or is it something else? In another part of the hearing, the person chooses to represent himself in court despite having a lawyer available on the Zoom call. Then not long after, he turns to the judge and asks how to get access to police body camera footage. That's the confusing part. If you're choosing to go it alone in court, it's important to understand at least the basic procedures. But instead,
advised Mr. Milton that he'd be trespassed from 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property. since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" Officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. Then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. In the Squally jail.
The charge of criminal trespass first degree. Is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Now, will I get a moment here to articulate anything?
I'll let you know. So this
Appreciate it.
item, I'm still working through the process. Thank
Of
you.
course.
All right. So, Ms. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
Okay. So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay.
Your Honor.
You even know the right term. Okay.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to.
Stumbles through legal terms and ends up asking the judge for help like he's trying to place an order at a restaurant. It's clear that confidence doesn't equal knowledge here. Let me know, have you seen someone more unprepared? In court, or does this take the cake? Yet again, we see another sovereign citizen who misunderstands the law. And yes, it seems like more of these cases are popping up. It's almost as if there's a group somewhere teaching people how to misread the Constitution. These individuals often try to argue their case with zero legal background. And while it's concerning, it's also a little baffling how convinced they are that their approach works despite repeated court losses. Some blame politics or misinformation online, while others think it comes from following certain online experts. Whatever the cause, it's clear this trend isn't fading, yet what do you think is fueling it in 2025? This hearing was something else and surprisingly entertaining. The judge's dry humor and reactions made it hard not to laugh. At one point, the defendant claimed he was kidnapped, referring to a lawful arrest.
Represent you, you're going to have to figure all that out yourself for purposes of
Okay.
today.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court
Read
order.
your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything
Okay. Is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay. Why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been
reading.
Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
I know all I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so what the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay. Anything else?
That's it for now.
Okay.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say that can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
That's when you realize just how far off base these interpretations can get. If getting arrested becomes kidnapping, then what's next? Calling a speeding ticket theft? Unfortunately, this kind of twisting of legal definitions seems common in these circles. No matter how many times their arguments fail in court, some people just double down at the end of the day. The courtroom is about facts, not personal theories. What's your take on this case? You think this individual truly believed what he was saying, or was it more of a performance? Thanks for watching, take care, and feel free to share your thoughts below.